Okay, what was your question again?
I'm expressing on the IRS account. And why can't we just send in and make them the trustees of the Form 56?
No, that's too simple.
Yeah,
We can't. I think I would want to make something a little more detailed and make it more of my own. Rather than use that form.
yeah, but we got principle.
Hello?
Yes, go ahead.
Oh, my understanding as far as the Form 56 goes is that's a notice of fiduciary relationship and not the actual appointing.
Good point. So that's sort of in support of a declaration or whatever.
It's kind of like notice of lien in the lien.
Okay, all the people on the call, are you also on the whiteboard in the meeting room?
Oh, no.
No, I'm not. No.
You might want to try to get in there. I posted a notice up there. And the notice really is, this will be the last dim call for Tuesday. We're going to switch it to the other call system that we were using on one of the other trials. And we'll no longer be using this 605 number any longer. We're going to switch to a different system, a different call-in number for Tuesday nights from here on in. And that will be listed on the whiteboard, but if you can't get on the whiteboard, if you got a pencil and paper, I'll give you the number for next Tuesday.
Good.
Okay, I've just started the recording, so we're recording now.
You're going to give out that number now? I'll push it?
Yeah, I just started the recording, so I got it on for the recording. So.
I have to update that number. There's boy. That number 2 number?
Right.
Is that the one?
Yeah, to announce it again, from here on in, the PIN number will not be used any longer. So it's going to be the new number for.
Is this the correct number for tonight's call?
Yeah, you should have dialed in on 605-715-4949.
Okay, thank you.
That's the PIN.
Hey, Christian, I haven't signed up for DimDim yet, and it's saying I have to sign up to get in, so is it really not worth it? Is it just a matter of accessing the new number for the call?
I'm really not going to
You down press star 6.
So I didn't catch what your response was.
Oh, hold on just a minute. Type on the screen here.
Oh, okay. Hello, it's Rhonda.
How you doing?
Good, how you, Christian?
Well, let your sister do that. Well, because we had a birthday. I'll get you some books.
Okay, let's see. I forgot what you asked again. Could you repeat that question, please?
Oh, I said that I was going to log into the DimDim, but I haven't actually signed up for it yet, and it's saying I need to, free register. So I was just thinking it might not be worth it if you're not going to use that anymore, and is the reason to log in just to get the new call information?
Well, yeah, it's on the whiteboard if you want to just enter into that. Either that or if you've got a pencil, I can give you the thing. I don't think we're going to go over anything by the whiteboard tonight. Of course, you never know, but...
Okay. It's just that I need to sign up for it. Get in.
Right. Read out the play music.
Yeah, I don't. Okay.
I just press star 6 to mute to speak some.
Look, Christian, I'm trying to get in the DimDim's room, but it won't allow me. I've been trying for like 10 or 15 minutes.
Okay, well, it's really not important till tonight. I don't think we're going to use it so much, but I do have the new number for the call next posted up there. But if you got a pencil and paper, I'll give you the new number anyway, so you got it for reference. So we will no longer be using the 605-715-4949 number, so don't use that next time. I'm going to do away with the DimDim thing. I don't think we really need it. We can do the same very thing that we're doing on a new number, and that new number is, here it is, 712-432-0075. And the PIN number to access that would be 917-030#. So again, the DimDim call-in number, the 605 number, we'll no longer be using it after tonight. So next Tuesday, dial in with the new number, which will be on a different service. And that number again is 712-432-0075. The PIN to access is 917-030#. So that's for next Tuesday. We're having a dual system here. I can use another system what we were using on some of the other calls, trying that out as well as the DimDim. I think it works out better than the DimDim. And I kind of like it a little bit better. And that's that 712 number. Although we're using a split system, like two separate systems running simultaneously, where the one whiteboard system is set up for Share Plus is called. And you get in through that, through the invitation, by clicking on the invitation button, it takes you to the website there where you log in. Or it could be sent a link from once the show starts. And then you access through the call on that 712 number. So we'll be running a separate whiteboard on a separate system and a separate call-in number. And the thing about this call-in number 712, which we didn't have before, is that if any of you are dialing in on a long-distance service, you're being charged for it, you can dial in that 712 number with Skype. That would be free then. Because it's not really using Skype minutes and a regular Skype call. It's using it like you would do a regular chat with Skype. What you would do is you click in the, I think it's free meetings, or what is it, free conferencing. Free conferencing, and add that to your Skype contacts. And then when you click on like you would a regular Skype contact, it'll let you in, and you can talk and listen on Skype. Instead of using your actual handheld telephone to access it, you can just access through Skype. So that's...
What's the code?
Okay, the number again is for next week is 712-432-0075. And the PIN access is 917-030 #. And after tonight, we will no longer be using the DIM-DIM, the 605-715-4949 number, or the DIM-DIM meeting room with the whiteboard. So we were trying a few different services to find out which one works the better, and I think that this setup we got next Tuesday will be a little bit easier, I think, and it's kind of consolidate the different things that we were trying, because we really had like 4 different systems we were trying all at once, and a little bit confusing because there's different call sequences, keypad, *6, *5, all the stars and stuff. So it should simplify, at least on my end, a little bit. So, and then I'll consolidate all the call-in numbers to really being basically just that 712 number.
Using rights food or no rights. We have the room of we bought. We use rights food. I just put it on the pills. I'll remember it all.
Okay, I really didn't have a whole lot to talk about tonight, so tonight's really more question and answer period, but I just had some things that came to mind that I was, on one of the other calls, and it came to do with the word from this older book we're looking at, which is a practical treatise of the law of trust, and it's by Frederick A. Lewin. It's the 8th edition. It's an 1888 book. It's a 2-volume series. But anyway, going through that, came across some interesting things, and actually it's a blueprint for what they're doing, really. So on page 2, if anybody has the book, was talking about the confidence in the person. And the person they were talking about was the trustee. And if you do a study on the word confidence, confidence is really broken down into Latin, which is con, and fidens, which is fida, or fidea, which is con means living, and fida, which is by faith. So confidence is really living by faith. So confidence in the person is living by faith in the person. So if I give a duty to the trustee, and that person's the trustee, and I'm really giving him the duty. In the old times there was just a confidence in the party, but that allows them, the trustee, to be self-centered. They took the property and wasn't dispersing the property onto the beneficiary. So this article, this paragraph started out with the confidence of the person to the person. So it was living by faith.
Yeah.
And really, nobody can do anything today unless they believe in it, unless they have faith. Because, you can't even go through a traffic light unless you believe that the traffic light, the other people on the other side are going to stop. You go through the traffic light by faith. You're living by faith today, and everything that you do, it just depends upon what your faith is based on. Anyway, this living by faith, this confidence, comes down to really, if I say the word interest, what is your interest in this case? Say, for example, I tell you, my interest is $500. And you look at me like in wonderment, thinking, okay, $500 is your interest in this case. And then you ask, well, where did you get that from? Well, I lent them $500. Oh, you lent them. So your interest is in here that I lent them. No, my interest is $500. So my point is that the word interest
is being defined two different ways, and two different people are interpreting the same word in different ways. One is thinking that the interest was really that I made a loan, and the other person was thinking my interest was $500. It wasn't that I made a loan, my interest was $500. So that's kind of like a portal word. And I really think most words are portal words. They can mean several different things based on, say, the context. But really it drives back to where are the original words derived from, and which ones are true and which ones are not. And which ones are we living by faith on? Which ones do we have our confidence on? But if we're living by interest, having faith in the word interest, but if you think it's one definition and I understand it to be another definition, then we have two different realms. We have public and private. So these portal terms, or these portal words, based out of Black's Law Dictionary, because all the words basically have been redefined under a legally speak, or whatever you want to call it, and you're being hypothecated and pledged into a different realm by the changing of the definitions. So when I talk about debtor-creditor, which would say the public side terminology of interest, well, that could be that I made a loan. Well, here it was all the time. My interest was about $500, which was private, say, under trust. And is the word trust a hypothecating word also? Is it a double word? Because if you do a study on the word trust, trust was not three parties in a specific building down the street. So if that building contained the grantor, the trustee, and the beneficiary, was the building the trust? Or was the trust the relationship between the parties? That the duty that was given to the trustee by the grantor, that the trustee agreed to, for the benefit of a third party in regards to specific trust res property. So are we believing that the trust is really a relationship? Or are we thinking that this trust is the building down the street containing those three parties? Saying one might be public and the other one might be private. And the building down the street could be, say, Harder Bank and Trust, where the real trust was the relationship held in the private. But you see, the key to the terminology is really, the understanding is really coming from the meaning of the word, of how you understand it, and of what the meaning of the word is based on, whether it be truth or lies. Then how do you know that you don't know? What do you base your truth on? Because everybody has to have a beginning point, because if not, everything is relative to your point of view. So you must have a starting point to base your truth on, a standard, a measure, something where all truth stems from. Make a comparison so that you can really understand what black is and what white is, or what public is and what private is. Because if you don't have a starting point, everything is just relative to your point of view. Then what you really have is chaos. Because everybody has their own point of view. And nobody knows who's right and who's wrong. So we put a Harder Bank and Trust Company down the street, which is the building that houses the supposed three parties. And that's where we put our money. My Bible tells me where you put your treasures is where your heart is. So when I go to work for the week, I get a paycheck on Friday. What did I really get? Did I really get $500 for the week's labor that I earned, what did I get for my $500? What's $500? Or $500 anything? What's your interest? Was your interest $500, or was your interest that you got lent money? Who is the lender? So the $500, $500 whatever it is, what did you get for your labor that you traded? Did you get $500 in Federal Reserve notes? Because today in the public realm, that's legal tender. Might not be lawful, but it's legal. So did the employer give you $500 in Federal Reserve notes? And then you took those to the bank and said, well, I just won't use all $500 this week. I'll put all of that into the bank. So I put that in a deposit. Did I tell them I wanted that back? And did you get exactly the same thing back that you put in? In other words, was it a special deposit? But think about it. If everybody got paid in Federal Reserve notes, when you put the Federal Reserve notes in the bank, what did the bank do with them? Did they hold them in special deposit, or did they commingle them and do whatever they wanted with them? And think about it. If everybody put special deposits into banks, being held in kind what you put in to get back out the exact same thing you put in, would there be any need for any credit? Because instead of you getting Federal Reserve notes that the employer, when he paid you with a piece of paper. How much is that piece of paper worth? How much is a check worth? So you took that check, which was credit, which represents what? Took it to the bank and deposited that in the bank. And where did the Federal Reserve notes come from when you went and got it back out? My point is, all these Federal Reserve notes, if everybody was requiring Federal Reserve notes, now every bank would be required to have Federal Reserve notes on deposit for every dollar that was put in. How many more Federal Reserve notes would be in supply? And isn't a short supply of something, doesn't that increase the demand? Isn't that really how they're controlling? Because we're really not asking, say, for Federal Reserve notes, but yet we use a check to substitute. So what is the interest? Is it really $500? Or is it the fact that I lent the bank the money? And what did I lend the bank under that particular situation? So it's really come down to portal words and what you understand. Whatever you're living by confidence, the confideo, and really that brings us down to the big banking debacle today through, say, securitization, of the real con. Because we've been conned for so long that we believe that the con is a real thing. And we're living by faith on the lie. Adding to the lie, perpetuating the lie, living the lie. Now, why don't we just wake up and start knowing and understanding what's really going on and say, hey, say no to drugs, because really there's nothing more than a drug. Because you're caught on a slave treadmill on a drug, Federal Reserve notes, because you're hooked. You gotta have. Gotta have. You're a junkie. And here all along, you were the one creating the money. And here it wasn't debtor creditor. It was really trust. But trust with a relationship, feeling that you were lending something, and lending is really gifting. And what is gifting anyway? Giving? And doesn't my Bible tell me I'm supposed to be a cheerful giver? I guess I must be a cheerful truster. Because gifting or giving is nothing more than what love is. So when I'm a cheerful giver, I'm a cheerful lover. And aren't I my brother's keeper? And how about owing no man a debt other than the debt of love? So, I mean, I could go into that a little deeper, but something to think about. What really matters in one's life today? You know, I walk out, say, at the end of my life, and I've finally cashed all these things in, you know. I've got this bag of gold, and I'm taking it to the bank, and some guy says, "Man, you're rich. You got this bag of gold. All these nuggets you've been mining all these years. You sure have spent a lot of time at that. You spent thousands and thousands of hours shifting through all this garbage, through a lifetime of living, and you got this mountain of garbage behind your house, humongous mountain of garbage. And at the end of your life, you're going to walk out with this little bag of gold. You're going to take it and put it in deposit. And this guy sees you on the way there and says, "Man, you're rich. You're rich. Look at that bag of gold that you got." I'm going to tell him, you know, that doesn't mean anything. The real gold is that garbage sitting in my backyard. The stuff that I've sifted through, all the facts and figures and the details and the studies, and the umpteen hours that I spent in siphoning through all this garbage to pick out this little bit of gold. And this little bit of gold actually is not the real gold. It's the lifetime of searching for the knowledge of that through that garbage. That garbage is worth more to me than that bag of gold. So you see, really the sum total of one's life of searching for the truth, that is the gold in one's life. And wherever you put your treasure, that's where your heart is. So what do you see as being the gold? The stuff you're taking to the bank? Or the garbage that's in your life in the backyard? Because I see the garbage to be more valuable than the gold. That garbage was the amount of time and the searching for the truth, which is more important to me, which keeps me going, than anything else. And then the fact that I can give what I've searched for and found to somebody else. And then they can take that and give it to someone else, and someone else, and someone else. Because the only thing that's going to matter when I'm dead, that I'm going to take with me, is that garbage in the backyard, not that bag of gold. So Trust Ambassadors, those of you that signed up for this, don't look at it for solving your simple problems. What you're really going to take with you is who else you gave the knowledge to. The garbage that you found in your life, searching for the truth.
And it said, no, okay.
And if you're going to give it to someone else, you're going to reap a reward that's 30, 60, 100-fold. And a fold is 10,000%. At least the same measure that you gave out, you will receive. So be cheerful givers in the knowledge. Pass it on through. Pay it forward. Because that's going to be for eternity. And what does eternity compare to the measly 75 years of life on this stinking earth? With everybody's garbage. But we don't want to be born in a barn and raised in a barn all our lives and have somebody come into the barn at the end of the life and say, well, hey, it stinks in here. And they're going to say to you, what do you mean it stinks in here? I don't smell anything. Well, you've been in the barn too long. Romans 12, 1 and 2 says, by the mercies and graces of God. Verse 2 says that you transform your mind. In other words, you have an attitude change, a paradigm shift, so that you'll be able to test and approve what God's will is, His good, perfect, and pleasing will. So that you'll be able to discern black from white, up from down, in from out, right from wrong. So I know what truth is when I see it. Truth based on righteousness. Not something that's been called black that's white, and white is black. And all we have is the tail wagging the dog. So we need to wake up and have a paradigm shift so that we can discern and we can live righteous lives in sanctification for those of us that are justified already in those three dimensions of salvation: justification, glorification, sanctification. Not in that order. But the point is that nobody can do anything without faith. And what that faith is based on really is the main focus. And everything we do here on this show is really right out of Romans 12, 1 and 2, which is the sanctification part. Sanctification in the book of Romans is really chapters 5 and 6. Justification is really chapters 3 and 4. And glorification is chapter 8. And there's your three dimensions of salvation. But not to be preaching tonight, or I could do that very easily, where I am pastor. But this straw man concept and everything that it entails has driven me in sanctification to sort through all this garbage so that I can pass it on to everybody else, all the things that I have found. There really is enough philosophizing, say, for tonight. Let's open it up for some calls and for Q&A. So if anybody has any questions, press *6, state your name and where you're from.
Christian?
Yeah.
How you doing, Harold?
Hey, Harold. Great. How about you?
I feel much better, thank the Lord. You could have kept on down that road. I was enjoying it. I think think oftentimes people need to hear the foundation from which we come forth.
Right.
And it makes
Right.
much more sense.
It's really not that sack of gold at the end of life that I'm going after. It's all that garbage in my life.
Because if it was about that, I would have gave that up a long time ago.
Yeah. Who are we glorifying? Yep. Are we glorifying ourselves, or are we glorifying the Lord? Yeah.
It said, if any man glory, let him glory in the Lord.
True. Let everything that has breath praise the Lord.
Amen.
Well, any other questions? You got?
No, that was just a comment. I'll let somebody else get in.
So, but when we found out, see, I had a 19.
Anybody else have a question or comment? Press *6. State your name, where you're from.
Hello?
Hello, go ahead. Who's this?
Oh, this is Bill, a Christian from New Jersey. How you doing?
Good. Okay.
Yeah, this is
What's
my
up?
first time calling. Well, just calling, to say I'm here, and I was looking forward to participating in the workshop. Is this part of the workshop?
Well, I guess you could call it so, but it's not really the workshop. The workshop is going to be 2 nights a week, 2 hours per session, 2 sessions per week, and for 5 weeks. So you get 10 sessions or 20 hours total. And I have more details on my website, which is movingtitles.com. So if you go to movingtitles.com, you can check out more detailed information on the workshops. It's been announced on the 16th this month. I announced it last Saturday.
Yeah, I was on that call, and I tried reaching your website. I can't locate it. That's why I sent you a bunch of emails to try to get the application.
Just go to Moving Titles, one word, movingtitles.com. Come up.
Well, that's what I did.
Can I make a suggestion? Because I had the same problem until Lisa told me to put it directly in your browser. Not in the search. Put it directly in your browser.
Okay. Well, I guess that's
I had the same problem.
Thank you.
You're welcome.
Christian? Yeah.
Yeah, this is Al. I have a question. I'm just curious. Does this workshop, will this include knowledge or understanding the process of possibly doing a 1099 OID process?
I'm trying to stay away from the debt accreditor stuff, and I'm strictly on the workshop, and with everything else, gearing it all towards trust.
So, would you do the so you won't do the 1099 OID as a trust or as a new entity?
Well, how do you mean
That being a
1099?
U.S. citizen, being an American, supposed to a U.S. citizen.
How do you mean to use the 1099?
Well, I don't know. I'm just curious to know if that was one of the things you're going to cover with that, or if you're not going to cover that.
Well, I don't.
I guess that'll be like a quick fix to get some funds in your pocket, you know?
Well, I think it's a quicker fix probably to get the whole ball of wax, the whole thing, and that's really what I'm striving for.
And that'll be better. That'll be
Yeah, in the long
get
run.
the whole ball of wax. That will be that'll get something in the shot, you know?
Yeah, I did uncover some things on the 1099 that were giving the reasons why they were seizing the funds once they got the funds back, returned to the principal, and that fact was revealed that really the beneficiaries are bankrupt because they haven't been paying the debt. So it's really a bill in equity that they're coming at you with, and a bill in equity was in the Gilbert's book that we've been using, a trust. And let me find it quick. On page 130 of the book, Gilbert's on Trust, that's section 456, where it talks about a bill in equity. So it says a common law, the beneficiary's interest was not subject to execution in the strict sense. The usual procedure was, and in many states still is, to file a creditor's bill in equity, or its equivalent, alleging no adequate remedy at law, and that is that the judgment creditor had sent out a writ of execution which was returned unsatisfied. And the equity court would then decree that the trust income, otherwise payable to the beneficiary, be paid to the judgment creditor to the extent required to satisfy the judgment. Apparently what they're doing is reading it that the judgment against the debtor, which was the beneficiary that hadn't paid the debt, has been seized. So whenever you get some money back from the 1099s, then they're seizing it to apply it to the creditor. That would explain perfectly why they're seizing the 1099 funds, freezing the funds for a lot of people. Because really they haven't paid the debt, and so as soon as you generate some credit, they're going to seize it. So again, it really, the 1099, applying trust principles, gives you the solution why 1099 seems to be frozen right now. The problem is that the trust is taking a discretionary action against the funds so that the funds can be withheld from the beneficiary because the creditors are trying to get the beneficiary's assets. So it's under a protective trust for discretionary trust. Now, if we go back and we correct the problem, which would be pay the previous war debts, pay all past debts, present debts, and don't incur any future debts, now the purpose of the discretionary trust or the protective trust no longer is needed. So the trust purpose has been fulfilled. And if there is no trust purpose, then the trust terminates. And that's how we're going to get the republic to come back. Because the whole republic has been held in trust, along with America, the common law, and everything else, is being held in the private in trust.
How long do you think it would take to get people up to speed to understanding that this is the actual way for them to remedy?
I expect a small percentage of them probably to see it pretty quick, and I suspect that most of them are going to take about 60 years. So it really depends on the person and how fast they pick it up, you know. Like we've been going over this book we just started on Monday on that, the Trust Ambassadors, this treatise on the laws on trust by Lewin. And I gave everybody an assignment to, you know, go as far as you can in the book. You know, and I asked be there how many had gotten how far. And one fellow said that he got like into he completed the first 3 chapters, which was like let's see, first 2 chapters are like 20 pages, and I think the next one's about 10. So he probably got in about 30 pages into the book so far. And, you know, I was interested, you know, what kind of bingos did anybody see? And nobody really came on with any bingos. So I don't know if anybody really, you know, saw any bingos. But boy, if you would have seen what I saw in there, you know, we really didn't get too far. We got into like the first 2 or 3 pages, and that was it. But stuff that is coming up, that's just in that book, You know, if you see what I see, that book is
Christian, you got Superman glasses on.
well, maybe it's
Because of
because I
knowledge.
flew through so much garbage, you know, because that's what I was trying to point out. You know,
Yeah, that's true.
the real gold is the knowledge that I gleaned from it, not the gold out of the garbage. It was the time to spend going through, sifting through the wheat and separating the wheat from the chaff. And the thing I was really looking for was knowledge. Because Hosea 4:6 says, I'm perishing for lack of knowledge.
Comes back to the basics. You're right.
Yeah, and that's really what I'm going to take with me when I get to heaven. You know, is the sum total of my knowledge, you know, based on what truth and whom am I glorifying. But anyway, I was getting philosophical on what the Lord was telling me, you know, today, and you know, He was really directing my steps, my path. And I really praised Him for the direction He was leading me. And I could see it. And I think that's just the whole point. He wants to make you aware that He's there so that He can keep knocking on the door of your mind until you finally open the door and let Him in. And He wants to tell you all about Himself. But a lot of people aren't listening. And sometimes He's got to put you between a rock and a hard spot, put you through the wine press of life, get you to wake up and pay attention. Because a lot of us are missing the truth. So if we want to take...
Where can you get this book, Christian, The Law of Trust by Lumen?
If anybody have it, you can do a Google search because it's right on Google Books. It's volume 1.
The Law of Trust by Lumen, L-E-W-E-N?
L-E-W-I-N.
Okay. I'll look into that. Thank you.
Make sure you get the 1865. So, anybody else have a question? Star 6?
Yes. Well, we're talking about books. What is the ISB number on the other law summaries book? I haven't been able to find a 2008 version.
Yeah, well, I understand that if you plug in this ISBN number, it comes up really listed as 2007, but when you order it, then they give you the 2008 version. So the ISBN number, here it is, 13978 0314 181 121. Okay, anybody else have a question or comment?
Hi, Christian.
Lewis in Arkansas.
Hey, go ahead, Lewis.
How do I get to your archives of your conference calls?
Okay, send me an email at christian@movingtitles.com or you could send it to my Hushmail account. And I also have a Hotmail account also. I'm trying to switch everything over to the emails on the movingtitles.com. Request a download link. I'll send you a page full of links.
Thank you.
Hi, Christian.
Yes. Go on. Who's
Hi,
this?
this is Jean Washington.
Go ahead.
I had a couple questions on what you were discussing earlier. Could you specify what you mean by, quote, the whole ball of wax? And also, how would we go about paying the past war debts?
Well, the whole ball of wax would mean, gain access to the account, unrestricted access to it. whatever amount's in there, 35 billion plus or whatever. And then also getting access to the unlimited amount of credits I could generate just by my signature alone through any kind of private instruments that I would issue. And how would we go about seizing that account? Basically, you have to terminate the past war debts, previous debts, present debts, and then don't incur any future debts. And really, you have the ability to do that by, bill of exchange, say. Non-negotiable, by the way.
Would you do the bills of exchange non-negotiable for the past debt and the present debt? Or I guess I'm a little confused.
Yeah, I'm going to do it all and say one fell swoop.
Okay.
Whereas anything that I owe, take care of it. I'm going to authorize my bill of exchange to take any amount that's necessary out of the account and pay that debt. If there's not enough in there, let me know. I'll put some more in there.
So would that be for our own debt, or are you talking about for the entire national debt?
Well, one person could pay the entire national debt.
Yeah, I've thought about that.
We each pay, just notify the bear, that would unlock it for ourselves individually.
Has somebody figured that out that you're aware of?
Figured it out. I believe we have figured it out,
About how to gain access?
It's really that hard. I think we're trying to search for something hard, and really it's right before your eyes. You just can't see it yet. You're looking for something that you're trying to visualize something and find it. No, you're not looking. And my sister took me one time over to Sanibel Island. She was doing some live shelling over there, because everybody thinks you go to Sanibel Island, you're going to get shells on the beach. No, the ones on the beach are crap, because they got the holes where the mohawks drilled through them, and they pulled them apart and ate them. They sat on the beach there, and they're all sun-dried and bleached, and they're scuffed up and everything. So the real specimens, you go out into the water, and you wade up to about chest height or knee height, wherever you are, and you train your eyes to look on the sand for like these, looks like stones, and she said, oh, I got one, and then how'd you find that? Oh, here's another one, what are you looking for? How do you find them, My eyes just weren't trained like hers were, and I couldn't see it. I was walking right over them. So your eyes have to be trained to see what you're looking for, or else you need to see what's out there. And I was looking at something, and I wasn't paying attention to the other stuff, what I thought was nothing, and I didn't see the nothing, but the nothing was something, what I wanted. I kept on something, which was what I didn't want.
Are you aware of anyone that has trained eyes that's done this successfully?
I don't believe anybody's done it successfully. At least if they have, I've never heard of it.
Okay.
I think we've had successes that look similar to it, because we think we've done set-offs, and here we haven't done anything at all. We just made bigger debts on the debtor-creditor side, and we've just added by discharge to the whole system and had more debt upon debt, because everything we did with Olson, Snow, and some guys doing recently with Geithner, they're putting it on the public debt side, and I don't think that's the way to go. Whether we put like a birth certificate in there under debtor-creditor relationship, really, and thought we were doing a set-off, and here I don't even think we're touching the private side. We're just making bigger debt, in my opinion. We didn't even put it on the right side. And number one, we didn't even come under trust. So I don't see how it could have worked. I don't think anybody has really made it work. I don't think anybody's really realized that it is trust. A lot of people, I'm going to say a lot of people, a few people have realized it's trust, but none of them have gone and applied trust the way we're applying trust. The only thing that they're doing with trust is really they're using asset protection, which is nothing more than debtor-creditor. You're trying to protect your assets from, as a debtor, you're trying to protect it from the creditor. And that's not private trust. We're not using the private trust. We're using it as a defensive, and we want to be able to use it as an offense. The thing is to terminate the trust, so to speak, because if the republic is being held in trust and not accessible because it's being withheld for discretion of the trustee, and everything else that goes along with it, common law, America, with assets and everything, all under trust, it's all being held under trust, protected trust, and when the purpose of the trust ceases and the trust terminates. And when the trust terminates, I'm going to have access to the funds because they're no longer held in trust. And really, we're talking about basic principles of basically merging titles and just trust basics of the four elements. And one of the methods of formation of trust, understanding that and using the moving titles platform to move the titles so that you could either merge the title in one entity, and when you do that, the trust terminates, or terminate the trust by eliminating the purpose for the trust. Or you could do compelling the trustee to do the duty. There's the 3 or 4 different options just so that we could do. But getting the basics down, seeing how things are operating out there is the big thing. You can't do the doctrine. You can't do the practical application of the doctrine until you know what the doctrine is. You got the cart before the horse. Any other questions?
Yeah, Christian, this is Danny.
Hey, Danny, go ahead.
What will give this process the teeth to make it work?
Well, again, the understanding of the trust is that no party needs to know or understand that a trust is being formed. Now, I doubt very seriously if a lot of those people even know that there's a trust in existence, especially the underlings, the lower echelon. And the fact that the trust itself operates in equity, and equity is where the power of the trust comes from, because equity will compel somebody from not doing something, creating a breach, and equity will compel them after a breach to do what they're supposed to have done. So the power is really in equity, and that's really what they're doing today to us. They're using the power of equity to get us. That's a past tense thing, because that's how it's really operating. That is the examples. If we were looking at it and seeing it for what it is, we would see that it's really the power of equity, and it's not really admiralty. It's equity is getting us. Under construment that we're the trustees, then the equity is compelling us to make the payments, and if we don't make the payments, then we're the ones that end up as trustees in jail. And what would compel these judges to act this way and give you what you were asking for? Well, their whole deck of cards house has been built upon a process and a system. They're like the legal Pharisees. They never miss a beat in their steps. They got to follow a legal regime that's set up. They have to abide by that. So if you got a rogue judge that didn't want to do what was supposed to be done on how they're getting you, then if you reverse it on them and they don't comply with it, I think the total system is going to hang that one rogue judge. And that's not going to have to be me. That's going to be them. They're going to have to either do what their deck of cards house says, or their whole deck of cards comes collapsing down around their necks. So that's the way I look at it. We're in a win-win situation. Once we know and understand, I don't care whether I'm trustee or whether I'm beneficiary. So does that kind of explain it for you?
Yeah, it does. But also, I've been in courts, and you use their own statutes and codes against them that they're bound to follow, and they won't follow it anyway.
Yeah, because you're not coming under by trust. None of us have come into express to trust. If trust is where equity is, then none of us were really in equity. We're at law, under statutes and codes. We traversed into their realm, and they got us on the statutes and codes. Because there's only one thing they're using against you, and that's equity, which is trust. And trust says, you're the trustee, and why didn't you pay? Because you're presumed to be guilty, and the only way you can prove yourself innocent is if you come up with a record of a payment, one that they'll recognize in their realm. So you're in a catch-22. Unless you come in from the source being the power, being under equity, from trust position, you can't get to where you want to go coming the other way. So they're operating under trust, under the skies of debtor-creditor, statutes and codes, and blah, 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 but here, trust is what was getting us. And it was, by the way, it was really all by our signatures, because our signature is what they need. So we granted it all. We're the grantors, and they're turning around and using it against us.
Yeah, they always come to us for our signature.
Yep. Fiction can't do anything. It looks for a signature of a real man. That's the empowerment of the charge that's given. It's granted by the grantor. So all along I had the power, I just never knew it. All I had to do was express trust, claim the trust, prove the trust, and then made a prima facie case for, say, a breach. Burden of proof shifts to the other parties, and then they're got the rock in a hard spot. Let the court of equity take care of it.
Yeah, equity's pretty harsh.
Yeah, we've been finding that out for hundreds of years now.
Right.
Christian?
Yeah, who's this?
Christian, can you hear me? This is Kim Marie.
Go ahead.
How are you?
Okay.
So, I have a question about, the trust and the tax and how it is that you're expressing the trust through the tax return.
Expressing the trust through the tax return. I think I was saying on one of the shows back that, why the tax was being withheld on the 1099s is because, the reason I just specified just a little while ago. Was that what you're talking about?
Well, I'm just asking, what tax returns do you file as a trust?
To express the trust, that 1040 form is the one that you filled out, and you actually expressed it as being a trust, because it was a trust declaration. You set up your status as trustee there. So you set up the individual master file in the IRS to be yourself to be trustee on the 1040 forms, which was a declaration of trust. Now I want to go back there.
The 1040 is, declaring yourself an agent of the state, which were actually foreign banks, as part of the trust. So I'm just wondering, I'm kind of curious why no one's really talking about the 1041s or, the estate forms. If we're trust and, everything is a tax, why isn't anyone talking about the 1041s and,
the 1041s right form to use because that would be too much truth in their realm. That would be exposing and saying, hey, the straw man account is a trust. I don't think they want to see that. They want to treat that straw man account as an individual.
I'm not. It's not to say that I'm using it as a straw man account. I'm actually using it as a trust account because I have a trust and I'm using it in that way. I find it.
Yeah, but I don't want that much truth. I couldn't bring that into the public realm and expose that because that would be commingling. I would be actually breaching the trust.
I don't see that at all.
And under secrecy, knowing all along that it's a trust, knowing how to operate as a trust, but when they, in such a way that they see it as being an individual.
So you file a 1040 tax return. You sign it as trustee.
Well, I'm going to establish the fact that I'm trustee on the trust, but I want to do it in such a way that it doesn't really show up in the public. I want to correct that master file first. I'm trying to reach up here and solve one of the problems up here in the leaves of the tree, and really I want to go down to the bottom and start there.
I got it, but everybody's got to pay taxes. I mean, no matter if you're a public trust or a private trust or a public person or a private person, everybody's got...
Not everybody has to pay taxes. Non-resident aliens don't have to pay taxes.
I didn't say pay tax. I said we have an obligation to fill out the forms and sign as trustees acting with respect to property held in trust. We are, as we restate ourselves in the federal level, we might move from 1040 to 1041, might, announce ourselves as a financial institution, which is what we are, and there's a form for all of that. I just find it curious that we're not talking about the tax returns, which are designed for and by the trustees of our current trust right now.
But that would be the 1041s you're talking about specific.
Right. Well,
trust.
That or the 590, or, there's all the charitable forms. I mean, there's a form for practically everything.
Right. I really don't like the 1041s. I haven't seen any evidence that's what we have to use.
Well, I guess that's where I'm kind of curious, and that's why I wanted to bring it up, because I have about 4 or 5 different people in my, community that have been filing 1041s as, trust, heirs of trust, and, it's just everyday, housekeeping for them to file a 1041.
But they're functioning under statute codes as a statutory trust, and now they have to file as a statutory trust using a 1041. Yeah, I'll agree with that.
Well, yeah, certainly.
That's private trust.
When your vessel, when your LLC or whatever it is that you have as your corp shell, all of us have a public entity. We have a Social Security number until people don't. I know that you're talking about several different avenues for people, but I wanted to make sure that we continue to talk about the other avenues people might want to take. Some of us have LLCs that I want to have that be a corp trust, and then I have a private trust that is a passive trust. A CRT is a passive trust. It's the one that the Getty family uses. It's what they use to pass on all their equitable titles and their assets to their grandchildren and to the nonprofit organizations that they use. There is a way to use and work with the private side of the trust accounts and benefit the public nonprofits called the 501c3s that are connected to the CRT. They're out in public, you could say. And I just find it interesting that, we're not talking much about the charitable trusts and, the 1041s, which are all estates and trusts, and becoming as executors of estates to disregarded entities and...
most don't know how to put the estate together, and if they don't know how to put the estate together, how are they going to know how it? If they don't know how it functions, how are they going to administer it? And that's why we're still stuck on the basics. Now, I thought we were 3 steps ahead before, and I did some searching around, talking to some people. I thought, I found out we're not 3 steps ahead. We're back on ground zero again. Most people can't express a trust.
most people don't want to pay their taxes and don't even know how to study an IRS tax return form to do it themselves. What the basics is that most people have been running from the trustees this whole time, which is the IRS. And I have found so much freedom in studying. I'm completely with you 100%. If people would really pick up and read more, I swear, I have been led by spirit through some of the most difficult IRS tax return instructions. Some of them are 37 pages long. Exactly what you're saying about when you go through Gilbert's Law and some of these other books you're speaking about. I'm telling you, I am so led by spirit through these documents. It's unbelievable what I see. And I'm like you. I'm asking people to read the same, just read these 37 pages and tell me if you see any ahas. And it's the same thing's happening for me. Like, they don't see what I see.
They don't have the basics down. It's like you had to sift through in your life a certain amount of garbage before finally you could see, okay, I see some truth right here.
Well, I had to surrender to spirit is what I had to do because I was done fighting.
Yeah, we have become more responsible for our lives and stop relying on the nanny being the alleged government.
Yeah, for sure. Absolutely.
So anyway, we'll get there eventually.
Well, thank you. Thank you for all the work you're doing, setting the groundwork. I appreciate it.
Hey, Christian, I got
California. Pardon me.
Yeah, I believe the gentleman was speaking was a little bit ahead. Go ahead.
Kevin in Nebraska, Kevin Commerce. I got a question. When it comes to the citizen and the American people, as I understand it, being viewed as enemies of the state, I've been doing some research on the possibilities of the three different, the Secretary of State, Secretary of Treasury, and the Attorney General all have to leave the United States when they get sworn in. And I'm wondering if it's those three offices that are key in some way to get us not to be an enemy of the state. And I don't think I've ever really heard you talk about that aspect, so I'm wondering what your thoughts are.
Well, I think the reason why we're enemies of the state is because we don't pay our bills. I think it's as simple as we pay our bills, then we're not debtors, then we're not enemies of the state. That actually puts us on the other side. So we're claiming all along that we're non-resident aliens, but we don't have any proof in actions that we are. Come back down to the Ashwater Supreme Court decision, which states basically that your actions really override your oral and your written. Because they gave an example in there. They said it was talking about state citizenship. They said you don't only have to just state that I'm not a United States citizen. You have to demonstrate it. You have to manifest your intent. And they gave an example of how to do that. They said that person would have to, say, expatriate. They have to move to, say, France. And then they would have to, say, join the military, and then the military would attack the United States. Now, that would be a manifestation of your intent. Unless there's some kind of manifestation of your intent, then they consider it that risen with your intent anyway. So it's not enough just to say, I declare I'm no longer, a citizen of the United States, or say, I expatriate out. You have to act like it. So you might want to check on that Ashwander case.
How is that spelled, Christian?
Oh, gosh. I don't remember.
Do you remember what year that was?
It's been so long ago that I look at that, I don't remember what year that was either. It was in a lot of citizenship stuff that I was researching at the time.
But the base of the case was what? Citizenship or expatriation? What was it?
It was citizenship. Was talking about citizenship. I think it was that fellow out in California. I was doing a lot of reading of his stuff. What was it, Michaels or somebody, McDonald. It might have been in his stuff that I was reading.
Okay. I appreciate all your work, Christian.
Hey, Kevin. Would you
Kim
mind say something about that real quick? Christian, you mind if I say something about that real quick?
No, go ahead.
Just as it regards the trust, just from a little bit from my understanding, is that when you become someone who works for the state, you become a state representative, and you're working for the people. Your state representatives, my understanding, are beneficiaries of the bankrupt corp. And so far as I know, that when you're going to take a position where you're going to be straddling both the public and the private, it's my understanding that you would have to actually declare your status as a trustee / someone who actually has access to their private side in order to be an entity, a communication entity for both the public and the private, because it's my understanding when you're a representative, you are solely public. You're in front of the black curtain the whole time. And in order to have access to the handshake behind the curtain, you would need to declare your oath to hold both positions in honor. Now, you could call that expatriating, or you could call it a large representation of what Christian is trying to have us really state ourselves by our contracts and our actions, which is we are both private and public, and we're going to operate with honor inside of that as a dual active participant. We are learning how to be private bankers and handle our affairs on the private side, which gives us the ability to have the private handshake and do it with honor and pay our debts and get back, keep our promises. And this is the intention. I like that Christian brought up the intention. I think it's really key to have the intention set, and then Spirit will guide you, and people around you will guide you to the keys that are for the next stages. So thanks for letting me say that, because that's always been a real big thing for me. Is I'm trying to emulate that straddle position, and I'm trying to do that through expressing the trust. So thanks for letting me know.
Kristen, I had a clarification question about the expatriation. Could I go ahead and ask that now, or do you want me to wait?
No, go ahead. I just wanted to give a definition of legal fiction, that's all.
Oh, okay. And you were talking about, the action of expatriating and the action of moving to France, etc. But what if you're clarifying that you aren't a United States citizen, but an American or a citizen of the United States of America, or one of the people of a de jure state? For example, if you're a Washingtonian or Texian or something like that has to do with the de jure.
Right, that was the whole point. The Supreme Court decision basically said that you could declare yourself to be something else, but proof of that was really how you acted. That was the manifestation of your intent, the way that you acted. So it has to be more than just a declaration. The declaration, the Supreme Court said, that was not good enough. You had to have the actions to clarify or to confirm the declaration.
You have to know how to act like a creditor instead of a debtor.
Yeah, in other words, declaration was the NOI or the notice of the interest that I was something else, but yet the actions was the material fact that substantiated. It was the SOI that supported the NOI. And really, that's basic government, which most people do not understand. Basic government and due process is really, you have a right to be heard at a hearing. The other party has a right to cross-examine. You have to give notice of everything. And you have to have an NOI supported with an SOI.
Okay, so you would have an SOI, and then you would record in the public record an NOI?
Well, the NOI is first. It's a notice. Hey, I'm not that stinking citizen. And then I must have facts to prove that I'm not that stinking citizen. Some kind of manifested act. And they gave the example, well, they left the country, went to France, joined the military, and then attacked the United States. Well, that may be a little bit overboard, but that's the example in that case.
Could we have more of a realistic example?
Well, I think if you're going to create an evidence like we do, nothing more than maybe just using the UCC-1 in the county recorder. That is a fact. That's a reporting of an act or a deed that would confirm by manifestation of your intent.
Okay. Thank you.
And then, like you said, act accordingly from that period on. Don't incur any more debts in this country. This country would be in their public realm. So you've got to continually act like a trustee, a beneficiary of that trust. And don't do any more debtor creditor debt stuff. Once you're back into their realm, and what you did is you commingled your funds, your actions, with the public and private, and they said, you don't know what you're doing. You're incompetent again. And then since you're incompetent, we're going to put everything back into trust. We're going to treat you like a kid again. And we're going to start taking care of you. But now you don't have any say how we're going to take care of you. They may be throwing you back for a stack evaluation on the minimal, and maybe the maximum, they may give you a prison sentence.
But Christian, by the mere acceptance of a pay stub, aren't you accepting a benefit and being thrown right back into that system?
Well, like I said, the pay stub should be for, the corporation, and that corporation would be taxable because its source of income was effectively connected with the United States business or trade. But what I'm talking about is gaining the trust, access to that where you're going to generate the private credit that's going to generate the interest on the public side. That interest is foreign source. And you're going to live off the interest, consuming goods and services for the real man, and you're not going to conduct yourself a business from that entity.
Christian?
The definition of a legal fiction here, what I came to mind is, says in Black's Law 8, it says legal fiction is the mask that progress must wear to pass the faithful but bleary-eyed watchers of our ancient legal treasures. So there's that mask, that straw man, that I must wear. So, but though legal fictions are useful in thus mitigating or absorbing the shock of innovation, they work havoc in the form of intellectual confusion. I mean, that really spells it out right there. I've got to learn how to manipulate this straw man in their public realm because it's a necessary evil state. It's essential to work with the private side. I don't really think that you're going to be able to divorce yourself from the straw man in the respect that he's not you. You're not tied with him, but yet he's your puppet. He's your face mask that you interface into the public realm, getting those titles that you need to get access to the real thing in the private.
Christian, I had a real quick comment.
All right.
Yeah, this is Donna Lee from Florida. Kay Marie was talking about straddling the public and the private. And I've been looking up a lot of definitions, and I think correspondent is pretty interesting. The third definition in Black's Law 8 is a securities firm or financial institution that performs services for another in a place or market that the other does not have direct access to. So I just wanted to point that out real quick. That's it.
Okay, what's your question now?
Oh, I had no question. I was just,
The lady
was talking about.
Yeah, she was wanting to speak, and I jumped in there with the legal fiction thing. If we can get back to it.
Oh, hello, yes, this is Dee in California.
Yeah, go ahead.
Thank you. I wondered if you had noticed the email that I had sent you about decoding of the IMF files and such, and a researcher, a law researcher, who there were some links to recordings where a law researcher had found, they felt, in the codes and statutes and the IRS codes where all of the reference were to the trusteeship and the trustee for the decedent and all this. A lot of references to trusts and beneficiaries and trustees, and this person had never really bought into the straw man concept with there being any account accessible until she found this information.
Oh, I remember that now. Yeah, I did read that.
And listen to the audios might be rather time consuming for you. I didn't know if some of the references would be helpful. Well, this person used to very actively and extensively do decoding and rebutting of the coding in the IMF files, and I was just wondering how that dovetails with what you're talking about, correcting the IMF, because I'm just not sure. Like I said, back then she hadn't identified the trust being mentioned in the codes, and so I do understand some of the premise that she was decoding with at that point. No, I'm really interested in how all this works in with the taxes and working in commerce, because kind of the way I see it is the straw man is necessary, and in commerce, in the debtor-creditor system of commerce, perhaps we are the trustee. That's perhaps the only role we can have in order to drive that out in the public, because we have to sign for everything. However, when the bill comes in is how you handle it, whether it's set up in the private. And, of course, institutions that are out here in the public, they're not able to handle the consciousness of us being then the beneficiary, and that they need to take it to the trustee on the private side to do the set-off. But for something like, I've heard a premise or a new thought, and I can't even remember where the site is for this, but I've kind of been crunching it in my head after looking extensively at all that 1099 OID stuff that was around a couple years back, was that, okay, the debtor institution of the trust or the straw man has to fill out that 1040 filing, and perhaps if we had never set it up in the first place when we filled out our first ones, we may not be able to do commerce. I don't know. I know people who have said they've done commerce for years without their Social Security number and such, but I wasn't able to embark upon that from the start. So, but certainly the more fluid way to do commerce is with your Social Security number and the straw man's account in the public. And so you're the trustee. The only way. But then when you fill out that form to report what commerce was done with that entity, I understand that when you do TurboTax, if you fill it out the debtor way, and at the end, if there's an amount owed, there's a coupon that you can print off. And so my thought and question is, can't that coupon be endorsed with the way that other invoices and offers in the mail can be received and endorsed, accepted, and endorsed as the grantor and sent in? I'm just not sure where it would be sent to, because, of course, sending it to the regular address, it may not be handled appropriately.
Well, I really think we've been doing it all wrong in the past, even. It's like, okay, I want to do commerce, but I really don't want to do debt. Now, I'm trying to show people a totally different way, according to trust, that it can be done.
So we can do commerce and not do that.
Yeah, we don't do that. So we do commerce interfacing with that straw man on a public side.
Right.
But in that account is really, say, interest. And we do commerce with the interest with that account. So it looks exactly like everything else. So there's really no red flags raised. But the interest is really derived from the private source. Then, therefore, it's not taxable once you prove your standing, and then you can use the W-8s and the IMYs in that.
And is that through an offsetted refund? Like, are you supposed to get that back, or are you just simply saying that the bills that are acquired on the public side are sent to a certain place for the trustee there to do the handling of the accounting?
Well, the way you make out the 1040 form is going to determine whether or not you're a debtor or creditor. So let's say
and that's not
a debtor versus a creditor being, say, a creditor through trust. Because a debtor is going to be, paying taxes, where a creditor standing through trust is going to be not taking any deductions or exemptions, because it's really all foreign source. There really is no income.
A lot of people in jail,
and then
zero returns, though.
Pardon?
I didn't hear you. Say again?
I said there's a lot of people in jail for filing zero returns, though.
Yeah, zero returns, yeah.
Well, and I understood that was the way the 1099 OID and A's such was supposed to be handled. That is a creditor, no deductions or
exemptions. Correct master file.
Pardon?
I don't believe anybody has corrected the master file.
Well, unfortunately, mine was until I did the OIDs. But I don't know if it was filed correctly. I don't know if it was corrected correctly. I just know I understand what premise it was corrected on, but I don't know if that established the correct standing on the trust or not.
Right. See, I'm talking about if we're going to go back and get the whole ball of wax, we're going to go in and we're going to correct the master file, correct it in such a way that we are no longer the trustees on that account. We are the beneficiary. I don't think anybody's done that. And then once we've established we're the beneficiary, now that matches up with the Steady Key Social Security Trust, because we're beneficiaries on that one. Because under the U.S. Attorney's Manual, that's 6-4.010, I keep going back to that, basically says that that IRS master file, that one, has to match, all the other agencies got to match that. So if we correct that one, whatever status is that established in that individual master file, that's the one that all the other agencies are going to look at and say they got to match up with. And that's probably what the court looks at. Get that file in front of the judge there, and they're going to say, okay, well, you've made out these forms as trustee. You're the trustee. And according to the book we've been started out, the trustees are debtors, defendants. So I could play that game as trustee, but really the ultimate goal is to go back in and correct that master file as beneficiary. Now they can't claim that they're beneficiaries because I have.
So is
that construe it? Let's put it that way. They can't construe it that it's under trust that they're beneficiaries.
So the way that I'm familiar with correcting that, and I do recall that you said about actions speak louder than words, and going in with a prima facie case to back up your claim. But the way that I'm familiar with correcting the IMF is, first of all, you have to decode it. You have to find out then what on there is the indicator of the trustee, debtor, trustee, or
not so much concerned what's in there. I'm more or less saying that I'm going to break myself away from that being trustee, and I'm going to set up evidence that I'm now beneficiary. From here on, that record has to be looked at as I'm beneficiary. Nunc pro tunc.
So you would so you wouldn't do a FOIA decode and find out what is the indicator that makes you the trustee and dispute that.
Yeah, because all that stuff is in there. I'm doing officially connected with a U.S. Business and Trade. I'm doing narcotics. I'm doing gun running, and all these other codes that are in there. They got you down for all these funds stuff that you're not even aware of that you're being charged for. Here you're doing commerce under this debt system, and that's what's got you in there also. So I need to pay all that. I'm going to just authorize a payment. Clear it all out. Zero it all out. Bingo. Gone.
So when your class starts, will we be enlightened in an orderly fashion of kind of how this is going? I feel like I'm learning so much from you. I highly respect and I appreciate what you share. And I love the challenge to connect the dots that I feel like I'm not meeting. Pardon?
People to think and, ask questions and throw things out there, challenge them. Yeah.
Yeah, and after being exposed to a number of different thought systems in the last decade, I guess what I'm trying to do when I'm asking you, what do you mean by correcting it? Because I've certainly been through a very, very regimented, orderly fashion of supposedly rebutting and correcting and rebutting the IMF, which is probably all gone to naught now. But I'm trying to understand that process that you perceive. What's your perspective of how you would go about that?
Yeah, I'm not going to identify each individually and say, that one's wrong, this one's wrong. I didn't do this.
I'm not asking you to do that. Just from your perspective, what, in a nutshell, what are you? I'm familiar with FOIAs and decoding and rebutting and notary process and silence is golden, all that. So we've got agreement, and so the record should be changed based on
that debtor creditor stuff myself, and I couldn't see what I see now unless I did come from that. But now I'm going to through everything that I've done in the past, reassess it all, but reassess it under trust eyes. Then I have to get those trust eyes first. That's why I keep on hammering these basics down all the time.
Right,
so you do. Trust eyes, the basics.
Yeah, because I find for myself that's what I do is I think of a new question, and then I understand my logistics of why I rose at that question. But of course, I probably rose at it from debtor creditor, and then I don't even understand that system. Like the courts are a total mystery to me, so I don't understand how to impose, that trustee relationship and beneficiary relationship. I don't understand how to superimpose that over that if I don't understand the system.
Right.
To go back and learn what the courts are and stuff like that, that's probably been my biggest challenge. I know what's right in my heart. It's just trying to learn, the moguls and how to go around them and whether you're supposed to be on your left foot or right foot and do it on a full moon Tuesday or not. That's all. That's the game. But I think I understand what the truth is.
Well, that's the starting point. The trouble is, the truth is operating in their realm is just the opposite. So you got to keep lying. You got to learn how to operate in the lies. Not that we're going to do the lies. We just have to know how to operate in that lie system.
Right. So you got to learn the lie system in order to operate in it so that you can apply the truth, but you have to learn the truth, how to operate that way too.
Right. So let's take, for example, the IRS that you're talking about there, the IMS file there.
Okay.
So really, instead of trying to analyze what is in there, I would be looking at it as trust eyes. Here's what I mean by trust eyes. I'm going to say, okay, what do I see here as being formed as a trust? Instead of trying to figure out what does this look like as debtor-creditor, because that's what you're really doing. I'm going to change my thinking around. How do I approach this that this fits into a trust? And the only way I can accomplish that is if I know the four elements and I know one of the methods of formation to get a trust. And I'm going to apply that to that situation and say, okay, how do I see intent, purpose here so that it would be a trust? Do I have all three of the parties, and who might they be? do I have specific trust res here that I could treat as a special deposit? Can I create by method of formation, by declaration or transfer, some way of forming this trust? Is there that elements and methods there? If not, how can I accomplish it? How can I turn it into a trust? Because I'll tell you right now, it's functioning as a trust. You just have to recognize it how it is functioning. It's all there. You just have to plug in the right things. And then you do it often enough, you'll start seeing it like the snap of your fingers.
Yeah, it's kind of like one of those, do you ever do those eye games where you look at the picture and you have to kind of fuzz your eyes to see the image jump out at you?
And there it was all along. You just weren't looking at it the right way.
That's what it's kind of like. Yeah, that's definitely what it's like.
Whatever mentality your brain has been washed in, that's what you're going to see until you start getting an opposite way of thinking. And my opposite way of thinking is don't look at things as debtor creditor. No, look at it as if I'm forming a trust. And that's why I keep saying, how many relationships are we forming day by day that we're not actually saying, okay, is this a trust relationship? Am I actually, paying attention to the relationships at the gas station, the groceries, how many times did I form a relationship today? It could be so simple as I gave somebody my pen, and said, I didn't even say anything. It was my pen. I wanted my pen back. That's really a trust.
So, but when we're handing it to the gas station attendant, pardon me?
We need to look at things as being through trust eyes.
And I like that you suggested that. So when we're working with the with the gas station attendant or the grocer or whatever, we're paying as a debtor. So we're actually.
Am I giving a debt or am I giving a special deposit? One is trust, one is debtor creditor.
Right. Well, can you have a special deposit when you're doing commercial? Commerce with the debtor creditor?
Well, if I'm doing
using a debt instrument.
Commerce.
Pardon?
If I'm doing a special deposit, it's really not commerce. Commerce is debt.
So irregardless of the instrument that's used, being a debt instrument, you can have it in your mind, an intention that you are making a special deposit.
Yes, trust operates solely in the private, except if you've got a statutory trust, because there's two types of trust. Statutory trust is in the public. Private trust, what I'm talking about, operates solely in the private. So if I'm doing a solely private special deposit in the public, I'm not doing debt. I'm doing private, non-negotiable. It's all under trust.
Even though you're handing a negotiable instrument over?
Yes, it's got my signature on it.
Okay, only if it's got your signature, not if it's FRN. Only if it's got your
signature. Well, where did an FRN get its power from?
My signature.
Right. So there's nothing really that they're using that hasn't really been derived from a real man's signature.
So for years...
It's been a signature all along from the private side.
Right.
You haven't been expressing it as a private side trust.
So in the illusion, it is looking like you're acting like a debtor, but you know you have to learn your intention and then follow that transaction. Are we still here?
Yes. Yep.
Okay. Follow that transaction, because you're really helping me a lot here, I think. So you follow that scenario we just kind of briefed on all the way through to the 1040 form.
Yes. What was your intent? What was your purpose? On a real private man, on the private side, you have to have censure. Censure means that you got to have knowledge and understanding in order to enter into anything. It has to be a two-party agreement. But on the public realm, censure isn't in their realm because that's fiction. Fiction doesn't have censure. Censure is a live being, a real man. So there is no knowledge or understanding on their side. They say knowledge and understanding is really gotten by the manifestation of the creation of a record that proves that you knew or understood, but you weren't sent here on that realm, and it didn't have to know or understand.
And it wasn't required.
Yes, that's the way it operates. Exactly the opposite from the private. The private, you had to have censure, you had to have knowledge and understanding. It had to be alive. But on the public, You don't have to know or understand. You look for the creation of the record, which proves that you knew or understood, even though you didn't.
Thank you so much.
Christian, what was that word? Sentience?
Sentient, sentient being is a live being, or sentier.
Gotcha. Thanks.
Sentier in Black's Law. About 2 weeks ago, I did a Saturday show for, I talked about intent, and we got into sentier.
You always refer to the 8th edition of Black's Law. Is that what you prefer for correlation with these studies?
Well, that's the latest one that I had. I understand they have a 9th edition. I haven't seen it, but,
So I'm accustomed to using older editions to be closer to the original definition, but...
For the private side, for the public side, I want to use an 8th edition, or say more modern.
So yeah, to keep up with the lingo of today.
Mm-hmm. Just as I was talking earlier on the show when I first started, the portal words and how they've been apothecating really comes down to the confidence in the word. You're living by faith, by the belief of the word, what you mean it, what you think it means. But if it means something different to them to what it does to you, then we're not communicating, and that's how they get us. So we have to learn a foreign language. One is private language, and which we already know, and then we have to learn another foreign language to us, which is public language. So it's a foreign speak. We all speak private language, but we need to start speaking a foreign jurisdiction language, a public speak. Knowing that the same exact words that we're using can be used on both sides, public and private, depending on your understanding of the meaning. But you must have a firm grasp of both meanings in both realms. And now you got control of both sides of the account. Public side being the minus liabilities, and private side being the asset side, the republic. It really starts simplifying it a little more. There's only just two realms. But we've got a hard time grasping multi-dimensional thinking. And we need to learn how to model things a little better. Because once you get the model down, it's the same cookie-cutter thing, one right after the other. Mm-hmm. There's nothing new under the sun.
Right.
I think the scenarios are very helpful for me. The scenarios, so I can start to see, to change my thinking of things that I'm actually doing every day. To start broadening that into dimensions of where I've been or where I want to go. To start understanding those relationships and the terms and the definitions. Start with something familiar. So that was a good example for me. Speaking of the commercial transaction. So
just start asking yourself the question every day, when I meet somebody, think in your mind, what kind of relationship am I forming here? Am I forming a trust? And if I'm not, how can I form a trust?
Kristen?
Yeah, go ahead.
Lorraine, New York. I want to just tell you that today I had the very same insight into the garbage.
Okay.
I had to share that with you. I just couldn't believe.
Thinking of that garbage is fun. I like that.
Well, I know about, I would say 10 years ago, I found myself looking at the garbage and saying, well, it's just going to get clean. It's just going to get clean. But I was very depressed about it. I was very bad about it. The fact that it exists and I'm looking at it. But today, I was actually glad in a strange way. So I'm very glad that you spoke about it. Anyway, next thing is on a practical level, right now, I'm trying to express set up an interest where I'm being offered, like the third time they're coming back and offering to make it a public expression of debt. And I've gone through everything with this, court and everything, gone in many certificates of protest, and I just wondered if you could speak a little bit about when I'm going to be doing a conditional acceptance on a piece of paper that doesn't have even an amount of money on it. I'm going to have to figure out, or maybe I don't even have to speak on the money. I could just, or the amount, I could just express that it's always been my intent all this time, as grantor, as the one who has given the credit or the credit card on the public side, because I'd like to almost take the opportunity to see if it's possible to set up that we could have a relationship where I would just pay it forward, and they would be, in other words, they could reissue the card on the public side. What do you think about that as a goal?
Well, as far as doing the accept for value or conditional acceptance and things, I believe that that's still debtor creditor, and I would be coming in and trying to express the trust.
Okay, so besides signing as grantor and...
Yeah, that's where it starts, but then there has to be evidence created which is the SOIs, to support your claim, which is the NOI.
So you wouldn't extend any more credit to them?
Yeah, but I would do it through a special deposit. So I'm not really extending credit to them per se like that, but I'm extending credit. No.
I'm sorry.
It's really a private instrument held in a private that's generating the interest on the public side.
Is it too late to do that? I believe since the contract was already novated, I'm actually starting a new contract because the presentment has the upper lowercase name, and they even got rid of the account number. There's no money amount. I mean, we're really from scratch here trying to settle something, and it really is a great opportunity if I could just use the right of just saying, since I lent the credits in the first place, I'd ask you to apply them, but here I would like to make a special deposit to pay forward for this account to express it in itself.
Where do you have to start first?
A certificate of deposit or something? I don't know.
We have, where was the first signature put on the contract?
The first original offer, they were offering the credit, my credits to me, and I never understood the nature of those transactions.
Right, that's where the trust was formed.
Mm-hmm.
Since you didn't know you were forming a trust, they did, and now they're going to construe it to be debtor-creditor, and they've been putting together all the evidence that you're a debtor. They got all these records created of things that you've signed, payments that you've made, you got a history, that when they come back you into court, they're going to prove that you're under debtor-creditor.
No, we've already gone through this. I've already, 2 years ago, extended them instruments. I've already gone through the motion where I've either...
Or debtor-creditor.
Right, it's debtor-creditor.
Have you created any evidence to substantiate a claim that you are the grantor on a trust?
Well, I have it on a UCC one and all that. That I have an interest in that account for this amount of money. and the proceeds thereof. So I have all that, but
you need 2 records to prove a claim.
What?
You need 2 records to prove a claim.
Okay. Okay, one's in the state. I guess I need one in the county then.
Yeah, the first thing I'm going to do is claim trust, and then the second thing I'm going to do is prove the trust. But to claim the trust, I got to have, in order to prove it, I got to have 2 records. So I got to have 2 records to substantiate the fact that I'm the grantor.
Okay, so I guess that means that I would need to go file in the county and then certify something out, and that's what I would send back to the offer that I needed an attorney to come after me as a notice. I would need to have it certified out, something from the county to send as a notice.
Yeah, that would be 2 witnesses. Yeah, UCC 1 and a county would be 2 witnesses to establish each fact. Now, what facts do you need to establish to prove your trust?
A notice of interest, right? You said.
Yeah. What are the essential? What's the character and nature of a trust?
There are the 3 parties: the grantor, the beneficiary, and the trustee and the beneficiary.
Okay. What are those called?
Oh,
you just
what
said
type?
It.
I'm sorry. What type of trust you mean?
No. You mentioned those entities. What are those entities called?
Trust entities.
You said parties. They're parties.
Okay.
Now, what is parties in relation to a trust? Think the basics in the book, in Gilbert. Do you have the Gilbert's Law?
I just have the PDF file.
Okay, well, that's good enough anyway for some of this stuff, but there may be some things that are missing and it could be wrong in there. So
I know.
Anyway, right at the beginning, it's talking about trust basics. Parties is one thing of what?
Okay.
Part is an element of the trust.
Are you searching for a word that I'm supposed to come up with here?
Yeah, I just gave it to you. It's elements.
Elements.
Parties is part of the elements of a trust.
Okay.
What else? There are other elements that are necessary for a trust. This is what I'm talking about. There's not enough people that know the basics about trust to go out and do any of this stuff just yet.
Well, then I'm back in better creditor to have to do what I have to do right in front of me.
Well, you may understand that better than trust, so,
I'll just try to add a little bit more and see if I can go back. And
what I'm asking is, do you understand that there are 4 elements to the trust, which is intent, purpose, parties. You mentioned parties, and then specific trust res.
Right, and I have an interest in the res expressed on a UCC, and which is the account. The res property is actually it's the account, but it's also the property. Really, is the as the grantor is the extension of the asset. Really, the property.
Yeah, but come back to the basics. Come back to the basics. How is this trust formed? I got to have intent. I got to have purpose. I got to have parties, and I got to have specific res. 4 elements.
Okay. Well, I've been trying to express as the grantor for the trust for 3 years now.
Yeah, but what you're falling down on is you don't understand the basics. I'm just trying to run through this so that you get a grasp on it.
Okay.
What you have to do is you have to create evidence or SOI to prove intent. prove purpose, and prove parties, and prove specific trust res, and then we got to move on to one of the four methods. You got to have at least one of those methods formation. Proof of that also. You got to have a declaration, proof of a declaration, or proof by transfer, or proof by appointment, or proof by contract. One of those four methods, formation, combined with the proof of the four elements. You can't prove those facts. You don't have a trust.
Okay, as a grantor, then I can appoint the CFO as a trust, but someone telling me really can't because they work for their employer.
I'm gonna mute everybody out here, and would you press star 6 to come back in?
Okay. Can you hear me?
Yes, I can hear you.
As a grantor, I had in another contract appointed them as trustee, and lately the CFO lately I've been told, well, you really can't do that because they work for their employer. They're not your trustee, and all you can really say is as the your brothers.
I don't really care what they say as long as I create the evidence that they've been, say, appointed, say, trustee. They are a trustee, and they ain't gonna get out of it.
Well, I appointed.
Instead of arguing their case, I'm gonna argue my case.
Okay, I guess.
Or else you're gonna traverse into the case on their case, and you're gonna end up being the debtor. I'm gonna come in on trust, express trust, argue trust, and not gonna traverse into their side of their arguments. I'm going to present my case, not their case. I'm not going to substantiate their case one bit. I'm going to create evidence necessary to prove that they're the trustee. If I've given them notice, then they're going to have to rebut that with some kind of evidence to counter my evidence that they are. If they don't, they just can't say an NOI, I'm not that stinking trustee. They are, because I got an SOI to support it, which is a material fact that they've been appointed, say, and they better have some kind of counter evidence that they haven't been appointed that's going to rebut my evidence, or my evidence is going to stand.
Okay, very good. On the step where is this always going to be a Mexican standoff, or is there a place where I could meet them?
I'm really not trying to get them to do what they don't want to do.
Okay, well, I mean,
else to force them to do what they're supposed to do.
Okay, that's good. I like that. And do you think that they're supposed to? Here's my question. In terms of my own ethics and feeling in putting forth my intentions, do you think that I believe that my credits that I'm extending as grantor are the most secure credits they could ever have. It's more secure than quote-unquote securitization. And therefore, for them to stay a viable company, they should be interested in that somewhere along the line in this economy. I don't want to say all that, but what I'd just like to, in terms of force, is have a way which I've never expressed before, that I am prepaying this account, as grantor, in other words, that I already was the grantor originally on the contract, and it's like...
Well, the problem is that you know who you are, so to speak, but you don't know how to express it.
Right, and that's what I'm trying to say.
In such a way that they can see or they must recognize.
Yeah, that's where I'm having a problem, so I'd like to come back and say,
The problem is you're not creating the evidence because you're not quite seeing how to create the evidence.
Yeah, I have half.
Is the third party that's going to force them into doing what I want them to do is the court of equity. I come in under equity, under trust, court of equity is going to compel them to do their duty. They're also going to be in contempt of court.
Okay, but just hear me out. Could it be their duty to allow me to pay forward on an account and have them issue a card so that the card could actually be not go through their public securitization?
Well, they're probably going to shut your account down and not issue you a card, but you would have to force them into doing that. See, what I want to do is I want to make it look like I want to give them what they want, really, and I want to give them a payment that they're accustomed to seeing that they won't choke on and spit back out at me, and that would be funds that are generated, which are interest in the public side, which I could convert into with no problem by writing them a check, because the interest is really credit. When I issue them a check with that credit, it's going to be the same as what they're accustomed to seeing, and they're not going to do anything about it because now you've effectively paid them.
So are you saying that I definitely want to accompany any offer with a 1099-A? So that they're forced to...
No. What I'm saying is...
do the 1099 OID?
Well, that's possibly I could do an OID on that and tax it back, but then the funds may get seized, but then all I need to do is ask for a receipt.
No, for them to take the 1099 OID and get what they are used to seeing.
Yes, because the IRS will correct the records. Because why do you think they still use the funds? But now I don't have any idea where they applied the funds. They might not have applied it to the bank. Maybe they applied it to some other account in there of somebody doing gun running or something.
If I do the 1099A,
I don't have any where their funds.
If I do the 1099A, I'm sorry?
I need the control to tell the IRS where to apply the funds. I don't have that yet. So there's some other steps necessary to go back and gain control of the account first, or otherwise you don't have any control of anything.
Well, I think the only thing I'd be missing is after the 30 days, after I extend this...
No, you're thinking too much debtor-creditor stuff of everything we've learned in the past. And you're not taking...
Okay.
Much in the box thinking with the accept for value, conditional acceptance, do a 1099 OID, and all that other stuff.
No, 1099A that I'm acquiring the interest in the account of this much. If you don't express
the word I talked about earlier today, interest is as what? My interest is $50.
Right.
But really, they're thinking your interest is they made you a loan.
Well, that's why the 1099A is important, because it expresses that you made the loan.
But it doesn't express a trust. It expresses debtor-creditor. That's what I'm trying to tell you.
Okay. Okay. My other question is, in terms of the ambassador program that you're speaking, that you're forming, I'm pretty isolated here, but there are a lot of people who are interested, but they don't know how to express it, and usually, and I am not that very articulate to know at which point I should begin with them. Would your ambassador program be helpful in helping us form, in terms of not just our own learning, but in bringing it to others? Because I actually have a group that said that they'd like me to come every other Sunday when I feel ready, and I just haven't felt that ready. But then your program showed up, kind of, and I'm just curious, would that kind of be helpful to how we would want to bring it to others as we're reshaping it in our own minds and relearning it in our own minds?
Yeah, the requirement for it to be a trust ambassador was that you have to have some people under you and to pass it on, and you're like the group leader.
Yeah, well, I mean, there is a group. They're a Course in Miracles group, And some of them have, debt problems and so on like that. And people really get very down about it. It's very hard not to talk with them about it. And yet...
See, the whole idea of the trust ambassador was that I like to have my 12 that are under me, and then those 12 have their groups of 12 under them. Because, I can only handle so many people. I can't handle everybody. But if I have somebody under me that I can nurture and bring along, my 12, and they have their 12, and they have their 12, so to speak, then this stuff gets out then.
Actually, I had a concept about, I'd say 4 years ago, of really just exactly what you're talking about, and that each individual, essentially, to have a financial system in this country, that's really the structure.
Right.
Well,
that's what I'm leading toward there. I can't help everybody. I'm better off to bring it to everybody, and I got to have just my 12.
So you already have your 12?
Well, I haven't exactly said, who is, but, the ones that are going to be showing the most promise, I'm going to be picking them up, The other ones have to fall into their groups. But, it comes back to the basics. Gilbert's book, the stuff that we're studying, it depends upon how much time you have per week that you can get involved in the studies on that. I'm going back and reviewing over the tapes, what we discussed about this November.
Okay.
But I believe you sent me an email, for a request to be into that.
Okay, I will.
And reference that.
I will. Thank you.
All right. Anybody else have a question? It's kind of late, so.
I had a quick question. I was just wondering how you would go about, I already got a pretty good idea, I think, but I just wanted to hear what you had to say about it. As far as like a family court situation, the case itself is the trust res, am I correct there?
Right.
And so the best way to go about handling this would be to terminate it, to move the titles and all that? Or breach of...
Yeah, you could make the trustee compel him to do his duty, or move the title, merge the titles, and terminate the trust.
And then, so the judge, if he was going to try to test me, he's going to want me to prove that he is trustee.
You'd have to have the evidence that you did the trustee is a key position because that's where you has to be a present transfer of trust property to the trustee, and that's when the trust really forms. So you got to have a record of transfer to the trustee.
So that's my next question. So then would you say, you're in a better position if you were the one that first opened the case, if you were the petitioner, supposed or whatever?
Not necessarily. If they're giving me an offer, I can turn the offer into the case, into the trust.
Okay, that's what I was trying to get at. All right, so it's just different. It's not a better position, it's just a different position. Okay.
Actually, it might be the better position because now you're going to flip it. You're going to come back in with your counterclaim, which is going to be your claiming of the trust.
Yeah.
Now your counterclaim is on top in first in, first out position, FIFO.
Okay.
And they got to hear your counterclaim first.
All right.
So your counterclaim is named as a trust, and now you have the proof. The proof goes in chambers to prove the trust.
So could you do all this not even having to go back into court, like to start? Could you do it all through the notary and not really even have to ever talk to the judge anymore?
Well, it's possible once they put that stuff in there that they may see what's going on, and then they know that right away they can't come back in, and they might say, close the case down right there.
If it's a really good reading, a nice letter, a really, really well put together one.
Yeah, and then again, you may have to come in and argue your side of the case. I can't say that's how it's going to do it.
But you wouldn't want to do. That's when you would get into the private versus like doing it privately and then giving them a colorable way to.
Right, the in-chambers hearing then and proving your case.
So but if you're going to be doing it in public, then would you start in with like using USC and all sorts of things like that, like, or no? Because then that would take you to debtor creditor.
Well, see, the public side of the case is all debtor creditor anyway.
Yeah.
Colorable side, and that's the colorable remedy I want to give them to bow out gracefully.
Okay. So negative averment and all that stuff would come into play, or?
The word necessary under colorable realm. The negative averment is not necessary for this process, like we're using under debtor creditor except for value.
Okay. And what if you wanted to go after your attorney that was supposed to be also a trustee? Couldn't you try to maybe get back all the money that you ended up paying to him, when in fact he was just dragging?
Well, when I claim the bonds, when I claim the case, all the bonds in the background are the proceeds there from the signature. So
okay,
when I
return of principal.
That entails that also. That encompasses them also.
So it's going to get a list of just everybody involved, the psychiatrist that the court ordered the girl to see, the child, all of them, all that money.
Yeah, the whole thing is trust res property. Yeah, all the fiction realm.
Yeah, they've all been bad trustees. All right. I think that's all for now. Thanks.
Christian, I just had one clarification. You were talking about the IMF.
Huh?
Did you say again what it was that you would correct on the IMF?
Well, we've set up our status on that IMF that we're the trustee. We need to create the information or tell them basically that we're not the trustee. We're changing it. We're going to be beneficiaries.
And could you do that through a notice to them, like an NOI backed by a SOI?
Yes.
Okay. You wouldn't have to go and request through FOIA to get a copy of the IMF and do anything with that?
No.
Okay. Thank you.
And NOI is notice of intent?
Notice of interest.
Of interest. And then SOI is?
Statement of interest. Really, that's out of Supplemental Rules of Admiralty out of the Federal Rules Handbook there. It's in the supplemental section under the Admiralty section under Rule C.
Would you repeat that again, please?
Okay. Federal Rules of Evidence.
Yeah.
It's under the Supplemental Rules of Admiralty section. You got your 86 rules, and right after that is that small little section that's running the whole thing called Supplemental Rules of Admiralty. And they run by letters, Rule A, Rule B, Rule C.
Excellent.
It's the Rule C.
Thank you.
In fact, I can even pull it up. Well, that book's on the bottom. Whoops, yeah, I'll follow it. Okay, it's Rule C4, is notice. Then it makes reference to C6, is the statement of interest. Well, in fact, right here it is under the 4 also. It's Rule C4 and 6. It talks about 10 days, 20 days, and 10 days and 20 days is 30 days.
Thank you so much.
Notice must be specify the time under Rule C6 to file a statement of interest or in or right against the seized property and to answer. And it'll be very interesting to compare that the release of the arrested vessel, where it talks about the special bond, which is really the special deposit. And we all thought this stuff was admiralty. Okay, and I don't have a question.
I had one more to follow up on that family court stuff. So as far as proving that there's trust, that's getting into I'm going to go to the UCC and I'm going to be listing the case number as the trust res.
Okay, what about the UCC again?
I'm going to be using that to prove the trust, basically. That's where that's going to be coming into play.
Yeah, so UCC won a record of evidence. That's one witness. And the county clearly pulled out, that's the second witness.
And that's what I would be giving in private if he wants me to try to prove the trust.
Yes, on each substantiated element.
Yeah, along with the colorable, and that should be a nice tight seal of deal.
In other words, you need to prove intent. You need to prove purpose. You need to prove parties, and the parties are grantor, trustee, beneficiary. Although you don't have to mention prove the trustee, although prove that it was a trust transfer, present transfer of property, you would.
Yeah.
Then specific trust res.
All right.
And one of the methods of formation.
All right, thank you.
Christian, I have one simple question, and hopefully more. What evidence, or where do you look to find that we each have an asset account?
What evidence do we have?
Yeah.
Asset account.
I mean, I know that it casts a shadow. Do you know what I mean? But is there any quote-unquote proof that it actually exists?
It depends whether or not you're going to say that is the proof. Because a Social Security account?
Right.
Oh, I'm concerned that's the proof.
Any other?
Well, there's the birth certificate, and the mother signed on the birth certificate.
Yeah. No, I can see that. To me, that's part of the shadow that it casts. Or I see it that way, and I might be looking at it incorrectly.
Yeah, I think we're too used to looking at the shadows, and the shadow is the only thing that we see, and we're not looking at the actual thing that's casting the shadow. We haven't trained our eyes to look, but all you got to do is track back to the signature. The signature is the key part. That's the beginning point of expressing the trust, but you never expressed it as being a restricted signature. That doesn't mean you can't come in and claim it and change it around, because you were the grantor. That's a fact. Nothing in the fictional realm is real. It's all dead. It's fiction. It needs real signature, which is represented by the real man or woman. And you got to track it back to the signature. Signature is the whole starting point.
Thank you. I have my moments of like peeling back the veil, and seeing stuff, and then it just, I obviously don't have a great enough understanding. Otherwise, I would hold on to it longer. So,
you have to play Toto. Go back and pull the curtain back.
Right. The other question I have is that you're starting your NTT classes very shortly, and I was wondering, will you take latecomers to that lesson, or do we have to wait until you finish and then offer it again?
I mean, like once we started the workshop and you want to get in after we started in 3 weeks?
Well, a week or two maybe.
I would think you have to more or less get on the ground floor.
It's not my preferred way of doing it. I'm just trying to keep my options open.
Yeah.
The answer is no, though.
Yeah, because really, if it'd be too far into the class, it's only going to run, say, for five weeks.
Oh, I thought it was 10 weeks when I read it.
No, it's twice, 2 sessions a week, consisting of 2 hours. So that's 4 hours a week.
Okay.
And then there's 5 weeks.
And then will you offer it again in the future?
Yeah, because I'm probably going to take a 2-week break, say, or a 3-week break between, and then start the next class.
The next class, meaning the same class taught again, or a higher level of class?
Probably, yeah, the same class taught again, yeah.
Awesome. Thank you so much. Have you announced yet when this is?
Yes, I announced it last Saturday. If you go to my website, movingtitles.com.
Yes.
Just type that in the browser, movingtitles.com, and click on that.
And it has the class.
Yeah, it's got the information on the classes. There's, I've got an update. I'm going to update that with. There's 2 options. I'm changing the wording a little bit to make it a little more clear. I'm giving really 2 options. Option 1 is you sign up for 1 workshop. 1 workshop is $2.99. Now you can buy 2 successive workshops at a discount. That's what option 2 is. So if you go through the first one, you can take, and you got the second one coming right after that. You can get 2 at a discount. You're going to save $100 on 2. Just go to the website, movingtitles.com.
I am on there. Thank you.
And I will be updating that website to more and more that I have time, and I'm going to bring a lot of information and stuff on there, so keep checking back with that site.
Christian, one of the things that would be great if you could put it on the site is the ISBN numbers specifically for the books you want us to have ready for that course, because there's a few different UCC books with the official comments that I found.
Yeah, that'd be a good idea. Yeah, I'll put the ISBN numbers on there.
Christian, I wanted to ask you about the workshops. Are they going to be kind of similar, or are they going to be significantly different, or is the second one going to be in like a supplemental to the first, or how is that working?
Well, I would think it'd kind of be in supplemental to the first, but then it depends on how many people we get that are first starters on the second one.
Okay.
As I see things progressing, we're going to have like a beginner's workshop, an intermediate workshop, and an advanced workshop. So we got to start with 1. So this is workshop 101 until we advance to workshop 202.
Okay, Christian, on the UCC with comments, which one do you normally use?
Well, I've got the Thomson West version.
Okay, because I ordered it today. The 09010 with the comments.
Yeah, I've got an older 2004 edition, so mine's outdated. But I got so much information packed in mine in the margins. I need a magnifying glass. I'm lost without it. So.
Yeah, I got 2 UCC books, and with something else you had. Oh, I got the. So I was working with 6 on the blacks. I just ordered the 9th, so I'll be ready.
The 9th also, but yeah, the 9th is out. Yeah.
Yeah. So I ordered the 9th. That should be here tomorrow, maybe Thursday.
And then we have a digital copy of the first version, the 1910 version. We got a digital copy of that, so we could use that.
I got 1 through 7 coming on that also, the digital.
Okay, great.
What makes this good is that you actually can search in it. A lot of the digitals you can't search. This one you can search through the different versions.
Where can you find it? Again? Where can you find it? Well, I'll be putting like the digital stuff that I've got. I'll be building it onto the website. A lot of the stuff, the information, will be able to get up there once I get, figure out how to get everything all up there. See? And what about the one that Harold ordered? Those are his. I don't know what he's going to do with them. Yeah, I know. Where did he order it from?
Actually, it was from a website.
Is that the website that had the seminar the other day? Sunday, I guess. Yeah, I think it is.
Yes.
Okay, I got it. Christian, I want to ask you this question. This Scarlet California.
Wait, you could negotiate that down too. I negotiated the price down.
Okay, how much?
I took $30 off of it.
All right, it took $30 off. Thanks. 30 years, that's good. Thanks. Christian, can I ask something real quick before we go? I know I asked this already, but my main concern when I get ready to express my trust 6 months from now on my home, now is the judge going to come back to me and say, we have an irrevocable trust that you signed and gave up?
Okay, you're referring to the county or something?
Yes. Yeah, well, the trust that I did when I purchased my home, or I created when I purchased my home. That's an irrevocable trust.
Closing, you mean?
Yes, right. If you're gonna allow me to tamper with it, due to the fact that it's
first of all, irrevocable trust. As there was an irrevocable trust, then he's admitting that there is a trust.
Okay.
Then you're gonna have to battle what he wants.
Okay.
If he's recognizing a trust and saying it's irrevocable, I'm afraid you just won.
Okay, perfect. That's what it was.
Because if you establish yourself as grantor on that trust and he recognizes there is a trust, then you could say, hey, by mistake, it's irrevocable, and I'm going to go back and say modify it so that it's irrevocable. Or whatever it was, I'm going to change it. So now they can't say it's not, I can't revoke it.
Okay.
So why would I revoke it if I can modify it?
It's because going back to the basics, you are the grantor.
Yeah.
Christian,
Yes, the lady was for first there.
I think he was saying that it already says that it's irrevocable, so how do you change it?
Oh, okay, I don't care what it says. If it was a mistake.
Okay.
Under a mistake, we do everything.
Okay. Thanks.
Wasn't his intent, wasn't his purpose. So it changed my mind. If I'm the creator of the trust, I can change my mind, period. If it doesn't reflect my intent and purpose, I can always change it.
So there's really no purpose to ever doing it an irrevocable trust because, I guess there could be, but it's the grant only one that could ever change it. Is that correct?
Correct, right.
Okay, thank you.
But I go in expressing the trust as a revocable, modifiable trust. So I'm spelling that out right from the beginning. So there's no question. Now, once I've got those two facts established that I can come back in anytime I want, I got no problem. So did that answer your question then?
Oh, yes. And did you say, I didn't understand the word you said. You said you were going to say it's an irrevocable, modifiable?
Well, it's revocable. I can revoke.
Okay, irrevocable, modifiable.
Not irrevocable. That means I can't do it. Irrevocable.
It already says that it's irrevocable.
Yes, it says already that it's irrevocable. That has nothing to do with me coming in and saying it was a mistake, and I can revoke it.
Okay. All right, thank you.
I can modify it, I can revoke it. Well, I come in and say that, once I correct it, I'm going to correct it in such a way that I can revoke it or modify it. I'm going to express it. This is a revocable, modifiable trust.
Okay. Thank you.
Okay. Hey, Christian. Okay, go ahead.
Christian, this is Dennis of Massachusetts. I want to ask you, have you decided on the night and times for these workshops?
Yes, check out the website, movingtitles.com. It says in there that it's tentatively set for Mondays and Thursdays at 10 p.m. Eastern Time.
Okay, thank you.
Okay, Christian? Yeah, go to the site and check out the facts that are in there. Go read through that one.
Okay, thanks.
Okay, Christian?
Yeah.
Listen, I meant to, maybe Harold can also comment on this if he can. But I received this letter I mentioned to you in the phone briefly. We couldn't really discuss in depth, but I received a letter notifying me that this attorney, on behalf of the bank that's in foreclosure with, says that they have an original note for me to review and copy. And I'm thinking of going to see them tomorrow. Is there any recommendation you can give me other than just go there and get a copy of it and front and back and don't say anything, or what do you recommend?
That's for Harold?
Well, you and Harold, or whichever one might be, can share some wisdom on this or experience.
You go first. Harold, you got a comment on that?
Okay, the first thing that I would do is, first of all, you would check for the wet ink. Check the back of the instrument to determine if the impression of the ink pen went through the paper. Because I've received reports that they're doing high quality scans. However, the one thing that the scan cannot do is put the impression in the back of the paper.
Would that impression fade with time if it's, for example, under a bundle of stack of papers, maybe on a box, or I don't know. I'm just trying to think out loud to see if it's possible. If it has pressure for a few years, wouldn't that impression, be not noticeable?
Well, I can't answer that question. I don't think it'll be ironed out. Even if it did flatten, there will still be some evidence that it was there in the first instance.
But you should rub your finger through the back of it to see if you feel any elevation.
Number two, I would look for the endorsement stamp.
In the back?
Back and the front. Here lately, they've been putting them on the front. They're not even hiding it anymore.
So if you have an endorsement or paid to the order or something to that effect, but then the document has been adulterated.
To a great degree.
Should I just make them aware of that, or just not mention anything, or leave it to discuss that in front of the judge when I meet with them in front of the judge?
Well, you may want to register an objection then and there that this is not the original. You might want to take somebody with you also as a witness.
Sorry.
Go ahead.
To say something to the gentleman who's asking about this.
Yes.
If you're asking for the original note, ask also for the title page, which will show if the mortgage has been satisfied.
And it also will show chain of title also of the note.
So ask for the original title page.
You're asking for the original note and ask for the title page, which will show whether or not the mortgage has been satisfied. It should usually say the mortgage has been satisfied.
There's something else you should be looking for too, to the guy that's asking. You should be looking at the upper left-hand corner of the note and look for the staple marks, or the little black dots when you copy something. And I would also ask for the allonge. It's spelled Allonge. I have an allonge sitting right here that shows that the guy who was sitting at the closing table is showing him as payor and showing the bank as the payee for $124,500.
So the closing agent should show in that allonge as the payee?
It shows the bank as the payee and the maker as the payor.
Okay. 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 Making some notes here. Okay, so I should make a copy of the front and back of the note and ask for a copy of the original title page, which will show that the mortgage has been satisfied. Is that correct?
Yeah.
Okay, if it doesn't say it's been satisfied, or it should say that. I mean, they've created the money to pay the seller and to put it to work, so I'm sure they've done through this process. They'll probably have a fancy scanned copy of it.
Yeah, but ask for the original note.
Yeah, well, I've already requested them. They said that they have it in their possession for review and copy.
Right, which is not what we asked for, because we asked for the note and all the documentation that we did under discovery be, produced at your location. Number one, they're in breach of court what you asked for. That could work to our advantage anyway. I wouldn't say anything while I was there looking at all, examining everything. I would say that for in court. That's where I would state that that was not my signature. And that instrument is stolen. Because I think what they're trying to do is give you an opportunity to look at it. And once you look at it, they're going to assume that you're going to think that it's the same one, and you're going to admit that in the course of the hearing. But now, what they're trying to avoid is for them to bring that high-resolution copy into court, because they will be committing a fraud if they do that. And they don't want this to go any farther than that hearing. So they really don't want it to go to case to trial.
Okay.
But the fact that you set up a controversy saying that it's not your signature, that note's been stolen, and they haven't produced a signature trail of assignment trail to prove that it connected with the original signer, the parties on the note, then they got a lot of problems.
Okay. I want to see if I can arrange to go on Wednesday afternoon. I have to go with my wife. She's the one that signed the note. And so we'll have to go together, I guess, and look at that together. Okay. So just look at it, make copies front and back, and just really not make any arguments there. Leave it for the court. Or just it's not my signature.
If they ask questions, I would say no comment. I would say my comments report. And we put motions in to confirm what we just talked about right just now.
Okay, fair enough. That's good.
All right, it's getting late and my dinner's on the table, so.
Thank you, Chris. Thanks for your comments, the people there.
Thank you, Christian.
Okay, remember everybody.
Thank you, Lisa.
Tuesday. Remember next Tuesday the number change, so don't be calling in on the 605 number. Be calling in the 712-432-0075. And with that new PIN number 917030 #.
Christian, once the workshop begins, are you still going to have Tuesday, Wednesday, and Saturday night calls?
I believe so, yes. I may move the Monday one to, say, another night, so, or maybe reschedule a little bit earlier or later, one of the two.
And is your moving titles Hotmail, account live at the website? Is that working yet?
Yeah, It's Christian at movingtitles.com. If you want to register for the workshop, the emails are also on the site there. Those email addresses are active also. It's NTT registration at movingtitles.com. Go to the website. All that's on the website there. The website page is movingtitles.com. Punch that into your browser, movingtitles.com, and it should take you right to the site.
What's the Wednesday night call-in number?
Wednesday night? Oh, that's Pop Shoe. That's 724-444-7444. And the access number for that one is 41875 pound. I believe you have to enter a 1 pound after that also.
What time?
That's at 8 p.m. Eastern Time.
Thank you.
Then there's the Saturday call at 7 p.m.
Christian, last comment real quick on this gentleman. I would try to take a professional with me and keep quiet at that meeting for that recording of the notes. So that
I'm going to hold that for later on if it goes to trial.
Yeah. But should they take a professional to inspect the notes? I would try.
No, I don't think they hold the notes. They just high resolution copies myself.
I know. But if you take a professional, they're going to believe you more. Okay, that was my comment. Thank you.
No, nobody can prove that is your wife's signature other than your wife.
Okay.
They can bring in any experts they want. It doesn't matter. It's what your wife says that matters. And if she denies it's hers, nobody can prove it is hers.
Great.
But there's been so many things that have happened, like attaching a launch and all different kinds of things that have occurred with that instrument. I mean, I wouldn't say it was mine either.
I'm just playing it safe. You know what I mean?
Well, the fact that you don't know where that instrument has been since you signed it all these years, I can't attest that that's my signature. If I was to test that was my signature, I would have to know where that was every minute up till now. You got it.
Yeah, and if there's been fraud attached to that note since it left your hand, if you say that is your signature, then you're guilty of fraud too, aren't you?
Well, if you say that's your signature, you're dead. They got you because now you just validated their case. Now they got the right to foreclose on you.
That, and if you say it's your signature when you don't really know for sure, you just lied in court anyway, so they're not really going to look at you as having any kind of mercy on you, are they?
Yeah.
They'll try to get her to say that that's her signature.
And they will press, and they will press, because if they can't get past that threshold, there is no case. We got a case in Cleveland, and they caught him out there, and the court is languished for about 3 months. Now the court is telling the plaintiff they got to do something or they're going to dismiss the case. Just learned of that yesterday, so they're about ready to dismiss that case, and that was a note issue where we caught him with the fraud. Nice. Harold.
Yeah, you got to listen to Christian and Harold. They are the most brilliant men I have the honor of talking to. Trust me on that.
We know that. Thank you very much.
On the Monday night call, what's the number on that one? Is that on the website?
It's a private call.
Oh. How do we get on it?
You have to get under a trust ambassador for him to bring you in.
Oh.
Either you have to be a trust ambassador or you have to be under a trust ambassador to get in. How do we find them? Well, send me a request to be a trust ambassador at one of the email accounts. I'll get it, and I'll look at it. Then I'll pick 12 or say, and then everybody will have to get under those 12. Okay.
Chris,
how do we know when you have them? Or who do you have? Pardon? How do we know who you have as an ambassador? Well, everybody will have to be signed up, notified who's under who. So we'll have to get it organized. All right. Thanks.
Christian, you're going to have 2 calls per week for 5 weeks. Is that correct?
On the workshop.
Okay. There's 2 calls per week for 5 weeks. Is $299.
And orders for the workshop.
Okay, and it's $299 per workshop?
Yes.
So suppose
And it should be a lot more than that, but Christian's really done a great job. Christian, we know your dinner's on the table.
Well, let him speak. Let him speak. What?
So that's about $3,000 all said and done?
No, you don't understand. There's option one, which I haven't got it up there yet. It's only $299 for one workshop, which consists of 2 meetings per week, 2 hours each.
Okay, I understand. Okay.
5 weeks. So that's 20 hours total.
$300 for the entire workshop?
Yes, yes.
Okay, thank you.
Now, if you want to buy 2 successive workshops, you want to attend one after that when we have the next one, probably about 2 or 3 weeks after that, then you can buy it at 2 at a discount. Save $100 on 2.
Very good, thank you.
Okay, Christian, have a nice dinner. Great call. Talk to you guys later.
All right, hopefully tomorrow.
Okay, bye-bye.
And the Saturday calls. What's for that one?
The number for that one?
I think I've got it. Yes, 712-432-8773.
Yes, that's a Saturday call at 8 or 7 p.m. Eastern Time. And you can also get that one off.
Okay, here's the radio. And the pin is 179441.
Yes, pound.
Yeah, that's awfully early, isn't it? That's 4 o'clock on the West Coast.
Yeah, that's early out that way. So I've been trying to make some of them a little different times, a little bit later, so that the West Coast people could get in on the like the Tuesday calls, the other ones.
Yeah, 9 o'clock calls seem to be the universally good time frame, if that works for you. Even a Wednesday call comes in at 5 o'clock here. Getting back from work or activities by 5 o'clock is a little pressing. We appreciate them either way. Okay, thank you all.